Good morning. Thank you all for joining another conversation of Wait One Legal Minute. Today I have a special guest, Mr. Torris Butterfield, a criminal defense attorney here in Atlanta, Georgia. He's been practicing criminal defense for about 23 years, and he is going to talk us through some pointers, some issues, things that may be helpful in the defense of the officers regarding who were recently charged in the Rayshard Brooks matter. And I think that it's important for us to have this perspective because, as I spoke a few weeks ago on 1380 WAOK with Wandolin Stokes, it is imperative that when we charge officers, we charge them correctly. We don't overcharge, we charge them correctly so that it can be proven. So we're going to have with us Mr. Torris Butterfield, who is going to give us the perspective of a criminal defense attorney who will take full advantage of how a defendant is charged. So we're going to bring him in. Good morning, Mr. Butterfield. Can you hear me? Good morning. So of course we're having some difficulties, but let me tell you a little bit about Mr. Butterfield. He graduated from he's from Miami, originally from Miami, and he went to Fort Valley State College and majored in English, and graduated from Mercer University, Walton F. George School of Law. He graduated from, he was on the dean's list at Fort Valley, and he is a member of the Alpha Phi Alpha fraternity, and he is affectionately known as Butter. So I am trying to get him back in so that he can discuss some of the advantages that a criminal defense attorney will take when, based on the charges that the prosecutor elects to charge the defendant. So let's see, I think he is back in. I am looking for him. Hello? Are you there? I can hear you. I'm going to ask my viewers if they can hear you. Let's see. We cannot see you, but I just want to confirm. Oh, there you are. Yeah. So whichever one, here you are. There you are. I'm going to cancel
Yes.
out this one.
Okay.
Remove. There you are. So now you're, uh-oh, I lost you. So if you all could just be patient, we are going to fix this. He is rejoining right now. I do apologize for all the issues. He was joining from two devices because one didn't show up. I see you again on my staging area. In the meantime, as I said, we're going to discuss our district attorney, Paul Howard, announced the charges for Officer Brosnan and Officer Garrett Rolfe. I have some videos here that I can, okay, we're doing the countdown again. And he should be able to come in this time. I have some video footage while we work out these kinks that we can go through. So in the meantime, what I'm going to do is show some of this footage that I saw before I have Mr. Butterfield talk about the charges, because he will make the distinctions in some of the intent that is necessary that I spoke about before that is problematic when charging a defendant with felony murder. So I'm going to try to see if I can get this to play correctly.
Charges that we have had filed today, signed by one of our Superior Court judges. These are the 11 charges against Officer Rolfe. The first charge is felony murder. This is the death that is as a result of a underlying felony, and in this case, the underlying felony is aggravated assault with a deadly weapon, and the possible sentences for a felony murder conviction would be life without parole, or the death penalty. Now, he's also charged in the arrest warrant with aggravated assault with a deadly weapon, and this is a count charging him for the shooting of Mr. Brooks, and the possible sentence for aggravated assault is 1 to 20 years. The third aggravated assault account is for the shooting towards or in the direction of Mr. Melvin Evans. Mr. Evans was the person who was seated in the car. We have the picture of Mr.
So while we're waiting for Butter to come back on, I just wanted to take a moment to discuss. Okay, here we are. Should be counting. I think this is going to work. There you are.
Hello. Good morning, everyone.
Hello. Thank you so much. I'm sorry about those technical difficulties.
Not a problem at all. Not a problem at all. I understand that you're playing a clip now of Paul Howard reading the charges or going over why he charged, correct?
Yes, I was, and I stopped it as soon as I saw that we finally had you. I was just allowing the viewers to catch up with what the actual charges were. So why don't you jump right in? I've already given a wonderful introduction of who you are and your background. So if you want to just jump right into the charges and how a criminal defense attorney will, I guess, navigate the charges in their defense.
Okay. First of all, the charges themselves, there is not a malice murder charge. That means that you intentionally and unlawfully took the life of another human being without justification or excuse. Rather, and that would have been a very hard charge to prove. But what Mr. Howard did instead is he charged felony murder. That's the first and most serious count. Murder, whether it says felony murder or malice murder, it still ends up with the same sentence. That means life in prison. And with a life sentence, you got to do 30 years before you're parole eligible here in Georgia. So whether it's felony murder or malice murder, the jurors are sometimes confused. If they just see felony murder, they don't understand it's still murder. And that's what the defense attorney has to express from the get-go. And you can't get into the punishment in Georgia. The jurors don't know the punishment. They only get to say guilty or innocent, or not guilty rather, and the judge does the sentencing. However, when I explain to a jury that, ladies and gentlemen, murder is murder. Don't be fooled just because it says felony murder, So we want to express that. But with a felony murder count, it simply means that you didn't have to intend to kill the person, but you must have intended to commit the underlying felony. So in this case, the underlying felonies would be aggravated assault against Mr. Brooks. So the aggravated assault is if you shoot someone, if you cause injury to their person and it's done with a weapon, whether it be a gun or stick, a knife, and you cause injury to them, that's one way in which a aggravated assault can take place. There are other ways in which you can commit an aggravated assault, but in this particular case, Paul Howard has to prove, when this case is indicted, each and every element of that offense, which is that he caused the death of Mr. Brooks. by way of committing the felony of aggravated assault. And that aggravated assault was to wit by shooting him with a gun, which when used offensively can cause death or serious bodily injury. So that is the count one. So they have to prove that he intended to shoot him and he was not justified. Same thing, you then go into the criminal damage to property. Someone's car was shot, during the time he was shooting at Mr. Brooks. They threw that in. That's an overcharge. He also charged 5 counts of aggravated assault. A bullet went towards some people, and then you had the aggravated assault against Mr. Brooks. And then you had the 4 counts of violation of oath of office. But what a defense attorney is going to do, and what I expect from what I've already read, is they're going to say that this was a good shooting, that death, no matter the circumstances under which it takes place, is always sad and it's final. But in this particular case, ladies and gentlemen, this tragic situation was caused by Mr. Brooks. He started a chain of events that led to his own eventual demise.
And that chain was initiated by his initial resist when they attempted to arrest him.
That is correct. The officer, bottom line is this: to make it very simple, and you want to keep it simple with the jury, is, ladies and gentlemen, policing is hard and everybody knows it. And in this particular case, these officers were extremely nice to Mr. Brooks. In fact, they were more than patient based on all the cases I've done in 23 years. They're going to argue that when the first officer, Brosnan, approached Mr. Brooks, he tapped on his windows like, "Hey, man, you okay? Can you pull your car over?" After a few seconds,
right there, Butter, if you don't mind, let me see if I can pull this in, because I think I actually have that initial encounter. And let me just kind of fast forward just a little. I think this is the initial encounter. That's when he's going back to his car.
All right, man. Just I'll move my
and
car.
Like you said, he just said, "Hey, man, you tired? You sleepy? Can you just pull
All
over?"
right, you good?
That's
right.
exactly right. He didn't approach him in an aggressive manner. And they're going to argue that these officers were very kind and patient in that they followed the standards, the standard protocol when approaching a situation. They got a call that this is not a case in which they'll say, "Look, this is not a case of racial profiling where they stopped Mr. Brooks because he was driving while black, or it was a high crime neighborhood." They got a call about a car blocking the Wendy's. They responded to the call, and when they got there, they were nice in the way they approached Mr. Brooks. So the story goes, as you see in the video, Mr. Brooks fell asleep after that. And then the officer, Brosnan, knocked again on the window, said, "Hey, man, are you okay? Can you wake up? Can you pull your car over?" Now, clearly, Mr. Brooks was coming out of a sleep. We later know that I think it's going to be admitted that he was at least under the influence of alcohol. The blood alcohol level is 0.10. We don't know if there are any other intoxicants in his system at that time, but we do know that not only was he just coming out of a deep sleep late in the morning after midnight, he also was a little bit under the influence of alcohol, but he was finally able to move his car. Officer Brosnan calls in Officer Rolfe, who is a DUI trained officer, because any officer would do. He just made a call over the radio, and I think it's 14 minutes and 9 seconds into the video. That's when Officer Rolfe arrives to the scene, and when he spoke with Mr. Brooks, the defense attorneys are going to argue that he was very kind and patient. He said, "Hey, man, how you feeling? What's going on? Where are you?" And now it becomes, we talk about state of mind of Mr. Brooks. And then again, I'm talking about, and I want your listeners to understand that what I'm talking to you about, I'm not getting into the ultimate question of whether or not Mr. Brooks should have been killed on that night. So I don't want anybody to say me being
And
here.
thank you for making that distinction, because I don't want the viewers to think that I am in support either way. We are attacking this, addressing this, having the conversation to inform people of what the standards are and what any good, competent criminal defense attorney will do to defend their client based on the charges and the facts in this particular case.
That is correct. So, and kind of what we'll do is we'll kind of I'm going to run through the facts that the defense is going to find favorable. Then we'll get into the law. And I won't take too much of your time to do it. But when Officer Rolfe gets to the scene, he's very nice to Mr. Brooks. And Mr. Brooks did not even know where he was. He said that he was in Forest Park, Georgia. And he said he was on Old Dixie Highway. And he kept talking about this hotel that was right across the street there. And the officer listened to him. He didn't interrupt him at all. But we all know that Mr. Brooks was on University Avenue in the city of Atlanta. So the officer pretty much at some point told him at 19 minutes and 21 seconds into the video, he said, "No, man, you're in the city of Atlanta." And then he respectfully asked that, would you mind doing some field sobriety tests for me? Mr. Brooks agreed. Again, now, the state is going to argue that Mr. Brooks was also jovial and he didn't pose a threat and he was nice to the officer. So everyone prior to the attempted arrest was cordial. So that's going to play in the favor of these cops, that you won't be able to paint them as some cops who were excessive and aggressive on how they approached him, or like they pulled their guns out, anything of that nature. I mean, so during this whole first 19 minutes and 21 seconds, that's a long time, because they could have arrested him much earlier, but they allowed him to do field sobriety tests, and they asked him how much he had to drink, and he admitted to drinking. He went back and forth on how many margaritas he had, but you got an admission of drinking. You got somebody falling asleep inside of the car. You got also, they're going to say he had a strong odor of alcohol on his person. And then he did not do well on the field sobriety test. And again, I do a lot of DUI cases. When he does his first 9 steps out on the walk and turn and to come back, he does 4 steps. And he says 1, 2, 3, 4, and 9. And he takes 9 steps back. And again, they're going to say he failed the field sobriety test. So but ultimately, based on, and then the next thing that happened is he submitted to a portable breath testing device, a handheld testing device.
Let me ask you this, Butter. They did not take that blow test until 40 minutes and about 50
41, 20, yeah, 4126 is what I have it. And
okay.
Yeah, at 4126. Well, actually, 4126 is the attempted arrest. So the breath test was probably where you're saying a little bit before that. But again, that is a long stop, right? 40 minutes. There was more than enough. Again, when you talk about probable cause, it's a low bar for the police. They can make an arrest if they have probable cause to believe that a crime was committed. And probable cause simply means, are there facts and circumstances that would lead an ordinary person to believe, 1, a crime was committed, and 2, that this person committed a crime. Well, with all those facts and circumstances, you got the falling asleep inside of the car at the wheel, you got the admission of drinking, you got the poor performance on the field sobriety test. All of that gives them proper justification to make an arrest. So, with regards to what the defense is going to do, is you're going to play up all of this stuff in very excruciating detail about how these officers were very nice, very patient, and they follow their standard operating procedures to the letter of the law, and that there was nothing wrong with the way they handled the approach, because they didn't have to stop him. He's already stopped. But the approach of Mr. Brooks, their questioning of Mr. Brooks, their cooperation with Mr. Brooks, all of those things are going to play into the favor of the defendant. So the thing happens at 4126 when Officer Rolfe says, "Hey, I believe you've had too much. You've had too much to drink in order to be driving. I need you to put your hands behind your back." And then at that point, we all know that that's when Mr. Brooks attempted to flee. They grabbed him. Apparently, it was a shock to everybody, right? They grabbed him because initially everybody was cooperating, and then he tried to break loose. And you can hear him saying, "Stop fighting, stop fighting." We know then that the defense attorneys are going to play up the fact that you had 2 well-trained, young, strong police officers. And Mr. Brooks, whether it was the alcohol or something else, he was strong enough, even in his intoxicated state, to wrestle and manhandle, and then actually swung a blow, according to the video, at the police officers. Not only that, he took the taser of one of the officers, who we know is Officer Rolfe, and then that's when the flee takes place.
And that
When
will play into the state of mind of the police officers in attempting to use the force that they did.
That is correct. When we talking about using self-defense, it says that, a person, not even police officers, we'll get into their standards, but a person is justified in using force against another to prevent that person's unlawful force against you. So we talking about proportionality. If somebody slaps you, you can't shoot them with a gun. You can slap them back, right? They fight you, you fight them back. They have a knife, you get a knife. They have a gun, you get a gun. That's kind of what we look at in this particular case. So it ultimately boils down to this. This case, ladies and gentlemen, is not about whether Officer Rolfe shot and killed Mr. Brooks at this Wendy's back in June of 2020. The only issue is, was he justified in doing so? And the facts are going to show that he in fact was. If you're going to find out that when Mr. Brooks fought these officers and took the taser from Officer Rolfe, he committed a felony. That felony of aggravated assault, when you fight the police officers, that's a felony right there. When you take their taser, that is a robbery by force right there. So now we already had the DUI, but now we have now we have them on a felony. And then, so we're in pursuit of a felon. So now here's what I expect this officer is going to testify to. That when this man punched me and it dazed me and I was in shock and I was in fear for my life and my safety. And when he took off running and he had the taser, I know he had at least my taser, but I thought he may have even had the gun from my partner. I didn't know if he had Devin Brosnan's gun or not, but because when he turned around and he had something in his hand, I believe that it was a gun that he was going to shoot me with, and therefore I shot back. His body was turned in a position. That's how he got hit in the back, but he aimed at me. So he reached over and aimed at me, and what I saw is the flash of the weapon in his hand that, in my mind at that time, obviously now looking back at the video, we know it was a taser, but at that time I was in fear for my life, and that's why I discharged the firearm. That is in a nutshell on how the defendant, I expect, is the only way that he will be able to defend this particular case. And I'll just say this to you with regards to police officers. It'll say that there's a use of force policy, City of Atlanta, real quick, under and they cite 17420, O.C.G.A. 17420. And obviously, an arrest for a crime may be made by police with or without a warrant if an offense is committed in their presence. Well, we talked about the ag assault that Mr. Brooks committed, as well as the theft or the robbery. We also know about the DUI. So they were right to arrest him. Everybody agrees about that. As far as the shooting is concerned, it says this, that under B of 17420B, officers may use deadly force to apprehend a suspected felon. Well, we know he was a suspected felon, and we know deadly force was used. It goes on to say that only when he reasonably believes that the suspect possesses a deadly weapon or object or device or instrument which used offensively against the person is likely to or actually does result in serious bodily injury. Now, what does that mean? Not only can an officer argue that I thought he had a gun, but even a taser. Is a taser defined as a device which, when used offensively, can cause violence to the officer? Can it result in serious bodily injury? Yes. Now, you've had attorneys for Mr. Brooks' family, my good friend Chris Stewart and others, they're going to say tasers aren't deadly. Look at the police manuals. They say tasers aren't deadly. But we know that's all a play on words, because those same lawyers have sued the police for killing people with tasers. We all know, and the defense attorneys are going to be able to argue that this, Mr. Brooks, we didn't know, no matter how good of a person he was and he loved his family, nobody suspected he was going to fight the police and break off that way. How do we know that if he had tased that officer and that officer goes to convulsing, that he wouldn't have went and got his gun and shot him and killed him? Because we don't know his state of mind. And that is it. That's why the officer was justified. You can look at cases like, just say Brian Nichols' case, who was able to overthrow a deputy in Fulton County some years back, killed a judge, killed police, etc. So the officers are going to argue. And again, this is all speculation of what would have happened. But under this statute, an officer can use deadly force if a fleeing felon has a weapon, a deadly weapon, or other device that can cause serious bodily injury to the cop or someone else. So whether the cop says, I thought he had a gun, or I thought he was going to tase me and take my gun and kill me with it. I just didn't know what he was going to do.
Let's take a look, because this is the video that shows the actual, and I love the way that this video was done. Let's see if I can make myself smaller. Here is the video that kind of walks through, and there's when he starts running with the taser. They've circled officer, that's Officer Rolfe, chasing Brooks.
That's correct.
He turns around and see, even in the video, you just see a white almost line from the taser that Brooks is pointing at Officer Rolfe. They're in the dark. He sees the shiny object or light pointed from Brooks. And by he, I'm talking about Officer Rolfe. And so the issue is the question will be, like you said, is it reasonable that Officer Rolfe believed that that object at the time, because that was after the scuffle,
Right. And in addition, you bring up something that's very important also. And again, an attorney sitting down and looking at all of this frame by frame, minute by minute, and when you're firing on all synapses, the lighting conditions are very important, because they're going to argue, look, this video may look clear to you, but this officer out there in this scuffle, you cannot see out there that well. It's dark out there. Let's do a night view. Let's go out there. Let's go back. We don't know when this case goes to trial if that Wendy's will be there, if there will be a new Wendy's there. But that's very important, because any video, if my first thing as a defense attorney, I'm going to cross-examine a witness before it comes into evidence to say, do you agree that the way this video is depicted is not the way the lighting looked out there, that it's been enhanced, so whether it's body cam or whether it's the cameras from the store, they don't truly depict the light as it appeared from someone standing there that night. So that's very important also, which again plays into the officer's mind that I didn't know what he had. You all are saying 2020 hindsight, we all know now that it was a taser, but we didn't know before that time. Those are the arguments that the defense makes. So can I go to another thing that I think is going to happen pre-trial in this case?
Absolutely, please.
Okay. So again, in this particular case, any self-defense case in Georgia, you want to file a motion to dismiss based on the immunity doctrine. That's O.C.G.A. 16-3-20-2. And it pretty much is, some people would call it, stand your ground, that the officers don't have a duty to retreat, but it stands for this, that if you are defending yourself or a third person against someone else's unlawful behavior, then you are immune from prosecution, both criminally and civilly. So when a defense attorney files this motion, the evidentiary standard is just like in a civil case. It's a preponderance of the evidence standard. So if this officer, if the burden is on the officer to file the motion, officers, I expect, would use those same videos, those same witnesses, especially, for example, in this case, the GBI has not yet completed its investigation. In all officer-involved shootings here in Georgia, the GBI comes in, they conduct a thorough investigation. They took the cop's gun that day. They took pictures of the cop's body. They took the cop's statement, and they're going to talk to every witness out there and additional witnesses. Now, they don't make an ultimate conclusion on on whether the force was justified or not. They gather the facts, and then it's up to the City of Atlanta Police Department to then determine whether or not the use of force was justified. Now, we know they've already fired the officer, but still, what's going to happen in this case if the GBI, has a different conclusion, or if City of Atlanta ultimately, investigates and has a different conclusion from Paul Howard? But bottom line is, you filed the motion based on immunity. You use those same videos. This officer can testify or not, but the argument is that Judge Beyer, but this is not guilt beyond reasonable doubt. All we got to do is get on the 51-yard line, as if it's football field, or if it's the scales of justice, it just needs to tilt on our side a little bit. And we believe, based on the preponderance of evidence, you should find that this officer was defending himself. And then that's going to put pressure on whomever this judge is in Fulton County. I don't expect this case to move to a different county, but that judge is then going to have to make the decision: do I pull the trigger, and if the community is mad with me or vote me out, I can deal with that? Or is that judge going to punt the ball and say, well, I deny that motion and let the jury hear it? Because but you're gonna put this, you don't lose anything by filing a motion to dismiss based on immunity, because what you also get, you get a free shot at Paul Howard's witnesses also. One of the things that we're apprehensive about as attorneys when we're going as trial attorneys is, you get all worked up and you get this one shot on how is this witness going to behave on the stand, etc. But when you have a pretrial motion and you get to call that witness on the stand, it's like getting a free shot at the witnesses. You trap them into their testimony, but and also you may very well win this motion, based on everything we talked about. So this is not a slam dunk case. I mean, anybody charged with a crime, a felony offense, you should be very scared for your freedom. People always say, well, Mr. Butterfield, what's your opinion on my chances? I'm like, man, when you go to trial, it's a 50-50 coin toss on who's going to win. But more often than not, the evidence favors the government and they win trials. That's why 95% of cases settle. But in this particular case, obviously this officer would need to be afraid going to trial, but Mr. Howard's office also is going to be afraid going to trial also. So they're going to try to, work some kind of plea deal. But in this case, if it goes to trial with some good attorneys, it's going to be a toss up on how this comes out. Now, do you have questions? Because I'll then go into, if you want me to, how jury selection is going to be very important in this case, as well as what the culture right now that we're having. So, but I think I've said a lot, and I'll let you jump in if you need to ask me any questions, or if anybody has questions.
Yes, and I would encourage anyone who's viewing, go ahead and ask us some questions, make some comments. We are here. Mr. Butterfield is an experienced, seasoned criminal defense attorney. Please remember, we are speaking about this incident, these charges, and possible defenses from a legal perspective. This is not necessarily our personal views. We are attorneys. This is what we do. When Mr. Butterfield is hired as a criminal defense attorney, this is what he does. It is what he's paid to do. Whoever is retained by Officer Brosnan and Officer Rolfe, this is what they will do. And all I want to do is bring this information to you so that you're informed and you're educated, because sometimes we are emotional. We're emotional about our opinions and how the officers should be charged and how they should be convicted. But there is a process. There is due process. And the more we know and the more you know as viewers, then the better educated and the better we can form our opinions about what is actually happening. So if anyone has any comments or any questions, this is the time to do it. So I have a question for you, Mr. Butterfield, about the charges.
Yes.
Other than felony murder, what is a lesser charge that might later be entertained if DA Paul Howard does not go forward with felony murder? What is the lesser charge that these officers could be charged with?
Mhm. A lesser charge that could be charged that is very rare. I've had one case and we got it dismissed based on an immunity doctrine motion, but it's voluntary manslaughter. I actually had a client initially was arrested, charged with murder. He was defending himself. Someone pulled a gun on him. It's a short story. He put his gun down, called the police, and they still arrested my client. He did everything the right way. And when that case was, so he initially was arrested, charged with murder here in Fulton County. But when we did this motion to suppress based on immunity, they had indicted him for voluntary manslaughter. And what that means is this: a person causes the death of another human being under circumstances that would normally be murder, but it was born out of what we call hot blood or passion, that anybody in that same circumstance would have reacted that way. And the example we learn in law school and that we give folks is, if you are married or you have a lover and you walk in and that person is in the bed with your best friend or your brother, and you just lose it and you get a gun and kill both of them. That's like an example that's always given. That's a voluntary manslaughter. So that is, what they could charge, but I don't expect. And then in that trial, that can be requested as a lesser included charge. But other than that, they've covered everything other than misdemeanor, battery, and stuff like that. So the charges that we have, we know that prosecutors here, as well as the United States, they overcharge cases. So for some people, from a defense attorney, you may say, well, look, if you think he committed felony murder, why not just say, I'm charging you with felony murder and leave the rest of this out? Because what they have done is charged in the alternative. They say, well, if you don't get him for felony murder, get him for aggravated assault because he shot the man. If you don't get him for aggravated assault, get him for violation of oath of office. So, it causes you to have a higher bond. The more charges you have and you have to get bond set, it makes your bond higher. Also, when you have to face a jury, the jurors get there and they say, well, thanks for coming to court. This is a criminal case against Mr. Garrett Rolfe. Let me read the charges. By the time they read those 11 charges, it's going to take 20 minutes. And the jury's sitting there like, I'm not saying he's guilty, but where there's smoke, there's fire. So it makes you look bad before they hear any facts that you got 11 charges against you. You've already had to post a high bond because there are so many charges against you. So, if it was a fair playing field, just charge him with felony murder if you think that he committed felony murder. But again, not just Paul Howard's office, but most DA's offices, definitely in this state, and by my experience says around the country and the feds, they overcharge for the reasons I'm telling you. It harms your chances to get out of jail. It causes you to have a higher bond. And if you make it to trial and without pleading out, it makes you look bad before the jury, in which it kind of diminishes your presumption of innocence. You got it? So you're fighting an uphill battle from day one as a defendant, okay?
So I have a question for myself, but I want to get this question in from Ms. Griffin, and I'm going to show the question. And her question is, does the fact that the taser is bright yellow come into play at all?
Yeah, it will come into play from the state's perspective. They will say that this officer knew that he's a trained officer, and he knew that he actually patted Officer Rolfe actually patted Mr. Brooks down. He knew Mr. Brooks had a bulge in his pocket that he said was money, so he knew he didn't have a weapon at all. So, and he knew his taser was taken, and so he knew it was a taser. So he knew it wasn't a gun. So that it's going to play in that sense that the state was going to try to lock him in to say that he knew or should have known that Mr. Brooks did not have a gun. However, as I told you, though, when you look at the statute, whether it's a gun or a taser is an object that's an instrument which, when used offensively, that means if you shoot somebody with a taser, it can cause serious bodily injury or physical harm. It can incapacitate the officer, and his weapon can be taken from him. So so I hope that answers that question about the taser light.
Thank you, Ms. Griffin, for that question. And Butter, just can you repeat that statute? That's 16322, because I'd like to include the statutes in my comments.
Yes, the immunity doctrine on here is O.C.G.A. 16-3-24 Dot two, and what that is, it's an extension of the castle doctrine, right? The castle doctrine is a man's home is his castle. That means if somebody breaking into your house, you kill them, you're gonna be justified. Well, this statute takes that castle doctrine out into the streets. You know, we adopted this after Florida adopted theirs, which we know they call it stand your ground. But here, it's just an extension of self defense. You got what I'm saying? The logic is this: if I was defending myself, and if I can show that before trial, then I shouldn't be prosecuted or sued. And that's simply what it says. And a lot of folks, I have a lot of progressive attorney friends of mine. I'm somewhat progressive myself, and we have arguments with regards to whether or not we need to change our stand your ground or immunity laws. And myself, anybody who is charged and they believe they were defending themselves, I want to be able to raise this, you know, and then if it's not granted, you still go to trial, etc. But there are some folks calling for in Florida as well as Georgia saying that we need to change these laws. Real quick, if you don't mind, can I give you the bad things in this case against Officer Rolfe and Officer Brosnan, so that I could talk about how the state real quickly is going to play it? Can I do that?
Let's do that, and then I would like to come back to the announcement of the charges, because you mentioned that one, they may have been overcharged, and that's not uncommon that they sometimes, overcharge. But also, I want to talk to you about how I've never seen an announcement of charge with so much information or so much evidence. I mean, it looked to me like a mini trial. We can come back
Right.
to it, but if you want to
Yeah.
start, but you
Yeah.
mentioned how sometimes the jury is influenced just by the number of charges, the number of
Yeah.
counts, right? So I want to talk
That's
about.
correct. That's correct. Well, I'll start there. Yeah, it is not usual that a prosecutor would get on TV and talk about why they charged a police officer or anybody and go into exhibits the way they did. I had a buddy text me afterwards, say, "Hey, man, Mr. Howard seemed to be the judge, the jury, and he had the trial. He did everything himself." But here's the deal. This we know is a high profile case. We know that we're living in crisis right now with COVID, as well as everybody protesting for equality right now, and to reduce excessive force by the police. So what they're going to say is this: there are no grand juries in Georgia right now. You know, we've been down since May, and the judicial emergency has been extended until August the 12th. So the Chief Justice has stated that because courts compel people to come there, we got to be careful on how we open up. So therefore, Mr. Howard is saying that, well, if there were a grand jury here, I would have put it in front of a grand jury. However, he states that in this case, unlike other cases, we had so much video. We had body cams from the cop, 2 of those. We had dashboard cams, 2 of those. We had people with cell phones, many of those. We had the video from the restaurant. We also have an initial autopsy where we have blood alcohol levels. So based on all of those things, I can swear out warrants against these officers. Now, we know as attorneys that a police officer has a right under Georgia law to appear at his grand jury. Now, he doesn't get to testify. He can make a statement, rather. He doesn't get to cross-examine witnesses. So bottom line is, some would argue that this is for show, that the argument is that, well, Mr. Howard is in a tight race for DA. He's in a runoff, and the reason he charged the officers a couple of weeks ago who tased some children, he charged those officers, and he's charging these officers. The argument, again, is that the reason he's doing this is that he wants the people in the community to vote for him as someone who would, indict police officers, and he has held them to what our culture expects, and that he's not doing this just because he is facing lawsuits and things of that nature. Now, that's what some people argue, that it's political. Now, Mr. Howard would say, I've been charging police officers, unlike many DAs in the country, and this is true. Mr. Howard has charged at least 5 or 6 officers here in the state of Georgia with this is prior to any runoffs or anything like that. But Then there are some people who are saying, he's waited 4 or 5 years, and why is he charging this right now? The GBI has not even done their investigation. So people are going to believe what they want to believe on. Is it a political move, or is
Mhm.
this a situation where the culture is driving policy right now? So we know, just in general, I mean, you got, the Quaker Oats is saying they're going to rename Aunt Jemima. You got Uncle Ben saying they're going to change their name. You got
Mhm.
Lady Antebellum saying they're changing their name. You got everybody's involved now. It's cachet. A lot of us, obviously I've been a defense attorney for 23 years. I've been out in the streets fighting for the people for a very long time. But now, and it's a good thing that right now it's socially acceptable to say, Black Lives Matter, and based on everything that happened with George Floyd and Ahmaud Arbery and all of these other folks who have been died based on excessive police force or allegations of excessive police force. It is now with that. Sometimes they say it's the video of George Floyd that has driven our whole society to act different. And Paul Howard's argument will be that he is simply doing what he's done in the past, and that whether it was coronavirus or not, he would have done this, and whether he was in a race or not, he would have done this. So those are the arguments about that. But now I'm gonna go into that other point real quick, and I'll get back to some questions. So how the state, from what we saw in the news conference, what they're going to argue simply is this: that this man should not have died. This was an excessive police force case, and there's no way that this man should have been shot in the back by this police officer. That the evidence in this case is going to show that yes, he fell asleep and he may have been intoxicated, but he during this entire 41 minutes and 26 seconds, he was cooperative. He didn't tell them a fake name. He gave them his license. He explained he was confused about where he was. He did everything right. Now, should he have struggled with the police and fought them? No, but he should have been charged with aggravated assault on police, and we would have charged him, and he could have gone to jail or gotten punished for that, but he didn't deserve to die. So this officer knew when this man was running, he was 18 feet away, and he shot this man in the back, ladies and gentlemen. That is what's unforgivable in this case. And in fact, Mr. Brooks didn't even fire his taser at the officer. The evidence is he shot it over his in a wild direction over
Right.
his own shoulder in the air.
Right.
So as a result, this officer is not justified. But guess what? I'm going to leave you with this, ladies and gentlemen. The evidence is going to show that when Officer Rolfe finally, after he shot this man to the ground, he stepped on him.
Right.
You're going to see the video. He kicked this man. He kicked him, ladies and gentlemen. And that's why you got the violation of oath charge in there. And then you're going to find his Devin Brosnan. Yeah, if he goes to trial, they're going to say that he didn't pull his gun or taser, but guess what he did? He stood on his shoulders, and that's why we had to charge him also. So, so that's how the state is going to say this, that, ladies and gentlemen, this case, when you look at the statute, the same statute is going to be used by the state. They're going to argue that a taser is not a weapon that is it's like one going to say black, one going to say white, one going to say up, the other one says down. They're going to say tasers are not deadly weapons. Look at it in the training manuals. So you can't, if the man tasered you, you just got to deal with it. Basically, is what they're going to argue, that he should not have shot this man because the man had a taser, that he was not a threat to this officer because he was running away. They had his license. They knew who he was. They would have called him, tomorrow. So that's what the two sides are going to argue. Culturally, there's an argument about, and so first thing is that this case is not going to trial next week. It's not going to trial next month. By the time this case goes to trial in a year or so, minimum, it's going to be a year or so before this case goes to trial. We expect that Mr. Officer Rolfe will fight for his benefits and he'll be on bond, same with Officer Brosnan. But when this case goes back to trial, we expect that policy changes would have come in our community, and you're not going to have the hot blood and raw feelings that you have now. People will still remember it, but it's going to be important that when you come around to it then, I guess first, some people are saying we shouldn't arrest anybody unless it's a violent felony. So, for example, on a DUI or what we call a drunk stop like this, they could have just written a citation and kept his keys and had somebody pick him up or whatever, or had him catch an
A
Uber. You
scenario,
come,
right? What would have been the worst case scenario if this alleged, defendant got away? What would
yeah,
have been
worse.
the worst case scenario?
Yeah, he beat the cops up, and he'll be charged later on. They'll go send out a fugitive squad to pick him up, or they could have actually called him because now we have a cell phone there. We know who he
Cell
is.
phone,
Yeah,
license.
we have that. So we could call him, etc. But again, they're saying that that's those are aspirational things right now because the bottom line is it, and that's why I'm going into that. Right now with the culture shift that we're in, there again, I got a lot of super progressive friends who say, man, nobody should go to jail unless it's a violent, a man got pulled off a woman raping her, or you got somebody who shot somebody in the head. A case like this, definitely they should have just written him a citation, and that way you wouldn't have had this excessive, he wouldn't have had to run whatever. But that's not what the law is right now in
Yeah,
Georgia. So
right.
the law is this. They can arrest you for a DUI case. And they were trying to arrest him and things went wrong. And then I was just watching CNN, and I saw Mr. Brooks in his own words, and it was revealed that he was recently coming out of prison, getting his life together, and he was talking about rights for those coming out of the system. He said that basically you got probation fees, you got fines, you're trying to get a job, and there's no one there to help guide you through this. It's like my probation, they should have someone helping us when we get out, get on our feet. Well, what's revealed in that, he said out of his own mouth that he was convicted of a false imprisonment and some credit card fraud stuff. So that's another thing that we call it Chandler evidence, but prior violent acts by a victim, if that can somehow come in, or if the door gets open, there's some different hurdles you got to jump through now that we have what we call the Georgia rules of evidence. But that's another thing that may may come in somehow. Definitely pre-trial, it's gonna may come in again also. With regards to this case, if it does go to trial, everybody has to remember that it's very difficult, first of all, to win a civil lawsuit against police officers because of qualified immunity. It makes it very hard to sue them and be successful at it, as well as convicting them at a trial. So first of all, it's been very hard historically to get an indictment against officers. Again, Paul Howard has been successful recently. We're seeing more indictments brought down, but historically, the grand jurors would come in and they rubber, because the defendant has no one there to represent him. They will indict a case. They indict a case. When the case gets to a jury, just picking that jury. Most of these, a lot of times, if you get a majority white jury, is what the studies have shown, those have been juries who are more likely to give the cop a pass and understand. Like I said, there was a study done by a professor, Philip Stinson, at Bowling Green University, and he says that jurors almost always give police the benefit of the doubt when it comes to allegation of misconduct or killing a suspect, according to that criminologist. And also the same thing, that's why the grand jury did not even indict in the Eric Garner case, or they didn't even indict it in Ferguson, Missouri. And he said that if it's related to their official duties in handling a street encounter that went bad, which is what we have here, juries don't want to deny the officer the benefit of the doubt, and they are unlikely to convict. And that, now, if they're in their personal, capacity, just like a citizen, they'll convict them 98% of the time. But it's
In
very hard.
uniform and on duty and calling for
Yeah.
backup and cordial interaction.
And the suspect fought the police and took their weapon. Now, again, I wish that Mr. Brooks had not gotten killed, but I know that the defense is going to argue that not only did he beat these officers up, because that's how you frame it. He beat them up, ladies and gentlemen. You could see it. He beat two officers up, and then he took their weapon and he was trying to shoot them with the weapon. So this officer was justified. We don't want to handcuff the police to where no one's safe. If that people can act in impunity, if they could just beat up the police officer. This man was scared for his life. How do we know he wasn't going to kill the cop? That is what, if you get a jury, what I'm going to now is that's what the studies have shown. And we know that based on historical factors that there's no over policing of various white communities like there is in black communities, so therefore you'll have 64% of white people saying that you shouldn't indict in a certain case, and then the opposite number of African Americans are saying, indict. But in this particular case, when you select the jury here in Fulton County and anywhere else, I expect Batson prevents during jury selection, Batson versus Kentucky, that you can't use race as a factor in striking a jury. That's pretty much, to make it simple for people listening. So you don't come out and say, I want to get rid of all the black people on this jury. Not saying that, black people going to convict him because it's a white officer and a black person dead. Black people convict black people all the time. But we, as attorneys, jury selection, you play into stereotypes. And one of the things that you want to do in jury selection in this case is, one, I want to have conservative jurors. I mean, I want to ask them that question. Raise your hand if you listen to Fox News. Raise your hand if you listen to talk radio and you agree with the commentator, 60% of the time. Because I'm trying to find, I'm asking all kinds, what kind of clubs are you in? Are you in Kiwanis Club? What do you do for a living? I want conservative jurors. I want jurors who, for example, people who run businesses or who are CEOs. Again, these are folks I'm looking for who are law and order type people. I want people who are law and order on this jury. And then if I want to try to get rid of some black folks, and here's how it typically happens, and black people do not realize this is happening, and you got to be real careful if you're called to jury selection. Nobody seems to want to take it seriously and serve, but what happens is you get to say this, and here's what they'll say in this case. If you're the prosecutor and they try to get rid of black folks without saying it, they'll say, well, raise your hand if you've ever had an experience with law enforcement that still sticks with you. And then they'll say, raise your hand if you, a loved one, or a family friend has ever been convicted of a crime. And then you say, well, tell me about that. So most African American folks know someone who may have been convicted, and they'll say, well, tell me about what happened to your brother. Oh, they treated him wrong, and how was he treated? So they'll strike him, right? See, we give enough. Then they'll ask questions like, raise your hand if you agree with if you have a strong feeling about the criminal justice system, whether it's good or bad. So you raise your hand like, yeah, I think the system is against us, and more of us are convicted. So you saying all the things that they setting a trap for you when you answer your hand like, yeah, the system is against us, and that my brother didn't get treated right, or when my sister got hurt, they didn't come out to the house. All of those are reasons that, judge, we didn't strike her or him because they were African American. We struck them because of their views towards law enforcement, right? Same thing with regards to this particular case. If I'm the defense attorneys for Officer Rolfe or Officer Brosnan, I'm going to say things like, raise your hand if you, again, have strong feelings about the criminal justice system. Raise your hand. I'm going to be doing the same questions that Paul Howard would do. Raise your hand if you had a bad encounter with police that it still sticks in your mind. Raise your hand if you've participated in any protests lately. Tell me about, what are your feelings on some of these famous cases that have been in the news, or is there any things that have, so again, you're going to answer all those questions, and then boom, you get kicked off the jury for non-racial reasons, but they're ingrained in it's more likely that I can strike you with these questions than the other way around. I hope I didn't spend too much of your time, but that's what I'm saying is, if you can get this case past the, if you get it to a jury selection, that's going to be very important in trying to formulate this jury, because most of the juries who have acquitted officers, they took like 13 cases of officers killing unarmed folks, and most of the juries that acquitted were dominated by whites on the jury. We know Walter Scott's case. Remember, they shot Walter Scott in the back. He was running from the officer. He got shot 6 times in South Carolina back in 2015. The officer goes to trial. They get a hung jury. Now, it was 2 years later in 2017 when the federal authorities charged him. He entered a plea and got a 20-year deal before he was retried. And again, remember, cases like Ferguson, Eric Garner in New York, the case in Louisiana, none of those cases were even indicted. So bottom line is it's going to be a tough case for the prosecution. It's going to be a scary case for the defendant. Officer Brosnan has an awesome attorney. He has Don Samuels, who's one of the preeminent attorneys in the state. Don Samuels also did the case in DeKalb County where an officer shot a naked veteran who was having a mental health breakdown. He was convicted, got 12 years in prison. So Don knows what he's doing. He has the lesser, the least culpable of the two officers. He says, hey, man, my client didn't pull his gun, didn't pull his taser. He rendered aid to Mr. Brooks. And what does he get for that? He gets charged. And Mr. Howard saying that we're cooperating. We hadn't agreed to do anything. But Don is going to give him a hell of a fight if they go forward, if they don't work out some kind of good agreement for his client.
So I did see that, or DA Howard did announce that there was participation, and I think the attorney said no, we have not agreed to. So what was
to which Mr. Howard says we've talked to him twice, so we know what he said. So Mr. Howard basically is alleging that we've interviewed the man twice. He's agreed to testify. Don Samuels is like, basically that's a lie, and my guy hadn't done anything yet. We want to make that clear. So we don't know at this particular point how that's going to play out, because that's small potatoes when you look at the macro view of this whole thing. Is bottom line is both of them have been charged right now. That's the big picture in this. That there you go.
Okay, so let me get this. I have a few other comments. I totally respect the opinions of both of you as attorneys. With all that is being said, and it makes total sense as to how defense attorneys will handle it. Bottom line for me, they will be justified in taking a life again from a legal standpoint. When will the human aspect of these cases ever come into play? He could have shot him in the leg or somewhere else to stop him. 2 bullets of the bat. How can it be justified? So let's talk about the first question. Let me address this part. I don't think that it is either one of our analysis that, well, first of all, I'm not a criminal defense attorney, but from my experience, I am not saying that they definitely will not be convicted. And I am not hearing from Mr. Butterfield that they'll definitely win. If anything, we're saying he said it's a 50-50 coin toss. But what I want you all to become knowledgeable about as lay people is what is considered. What are the statutes? What are the facts? How do they play? How do the facts favor each side? And how do the same facts favor each side depending on the argument? That's what I want you to learn and to become informed by, but do not take this information as either of us saying that they'll definitely get off. It is more difficult to convict a uniformed police officer under this particular fact pattern where the defendant has resisted arrest and taken the weapon of a police officer. I think we both agree on that. But I think Mr. Butterfield's overall conclusion about any kind of criminal trial or any trial is once you put the decision into the jury, we don't know. It is a coin toss. Do you want to add to that, Butter?
Yes, I definitely agree with everything you just said, and to address that second part in which this speaker wants to know, let's talk about just from a human standpoint. As I said early on in my comments, that no matter the circumstances under which death occurs, it's always sad and tragic and it's final. I think that everybody with any sense of decency would hope that there was another way that this could have been handled. And as I said, to answer her question, culturally, the shift has to be, how can we stop these encounters from becoming deadly? So here we got, again, a DUI stop that turns into a deadly encounter. Well, one proposal is that people should only get citations unless it's a violent crime that you're being arrested for. So if he could have been given a ticket and then be forced to catch an Uber home or sit there, and we're going to keep your keys, we're going to tow your car to make sure you can't drive, here's your ticket, sir. That's one way to prevent these encounters, because if we don't have to put his hands behind his back. And what I was getting to also is the allegation is that what snapped in Mr. Brooks to make him do this? It's my understanding, based on the speak, that we're going to find out he may have still been on probation. And in his mind, he's like, damn, I got a job. I got my little rental car. Everything's going well. I don't want to go back to prison. He said, I think he had to do a year or so in prison. So that, if we didn't have to even handcuff him, maybe we wouldn't be here. So the proposals are to, let's see if we can reduce the interactions that police are having with suspects. Some people are saying, we need different training. But so long as officers have guns, we expect that the guns are going to go off. You got it. But some people are saying maybe in cases like this, we need co-responders. So what if at this time the officers were required to call a social worker, someone who deals with DUI cases, or someone else who could have talked to Mr. Brooks and differently? Did they require that a family member come out there to keep him calm? Things of that nature. We're exploring different things as a society right now. We're in the midst of a culture change right now. I mean, so many people are protesting, and it's across racial lines that everybody's saying now, hey, let's address the inequalities that we have in wealth. Let's address the racial inequalities. Let's talk about excessive force by police and systemic racism. These are things that were heretofore being fought for, but now it's again, and again, it's the young folks. I mean, I've been to 3 rallies in Atlanta. I just got back from DC, and the folks are average age from 17 to 25. I'm 48. I felt like an old person out there, but the young folks are saying they want change. They're not afraid to address that. Yeah, this is not right. Systemic racism does exist. And as we see now, our politicians are trying to pass laws. The senators and the Congress folks in Washington are on the federal level passing reforms. Here in Georgia, they have the last days here in the legislature where they're trying to pass a new hate crime bill. So to her question,
426, yes, HB
so
426. Let
yeah,
me
so
just interrupt you to go to a few more comments, because we'll have to wrap it up. And Tim Perry says sometimes when they're in uniform, they think it's a pass and can get away with doing unlawful policing. And yes, I think we all agree with that. And that's why the new legislature is coming out. That's why we're protesting. We have got to make a change and bring it to the forefront. Paula Burr, just letting you know I'm watching. We have Marilise Orr, baseball mom, former baseball mom. You both have my respect. Very informative, and thank you. And I appreciate you watching. It is imperative that we reach all of our friends, all of our colleagues, all of our baseball moms and dads. I mean, it's crossing color barriers, socioeconomic barriers. We have to have these conversations. Here's our dear friend, Butter, Kevin Adamson, says, 2 of my favorites. Y'all make some interesting points. Yes, so I'm going to wrap up. Yes. Our dear friend. Listen, if you need to get in touch with Butter because you have a criminal issue, I've included his information in the comments. But his name is Torris Butterfield. He is an amazing criminal defense attorney. His number is in the comments. Just scroll down. But why don't you just say your number? Here it is, 404-522-5056, and let our viewers know how else they can reach you.
They can also reach me at butterfieldlawfirm.com. That's our webpage. Also, my cell phone number, I give it to my clients, is on my business card. It's 770-883-4681. I'll be happy to help out if I can.
Great. So I've included all the statutes that we talked about in the comments because I want my viewers to be informed. Y'all can click on these statutes and see what we've been discussing. I've also included the article from Phil Stinson that Mr. Butterfield spoke about. Listen, I'm just trying to get the information to you all. It's necessary. These conversations are necessary. Butter, I would love for you to come back on and cover other related stories. I spoke about Ahmaud Arbery when that incident happened, but we have to wrap it up. But I want to invite you to come back on because this was amazing.
Well, you got it. You know, I won't go on CNN or any of those shows, but if you call, I'll come running. So I'm always there.
Well, I appreciate you. Thank you for your time.
Okay, you're very welcome. Let me know if you need anything else. Bye bye.
Okay, thank you. Y'all have a good one. I will see you all on Tuesday and Thursdays at 11 o'clock. Please share this, share the information. I appreciate the support. Like my page and ask me questions, email me questions at wait1legalminute@gmail.com, or you can continue to make comments on this feed and I will respond. Just thank you so much. There must be a storm or something happening because now the electricity is flickering. So thank y'all, and y'all have a good one. Have a wonderful, safe weekend, and everybody do your part. And happy Father's Day. Yes, thank you. Thank you for that. Yes, happy Father's Day, Butter. I should have said that. Everyone have a good one. Bye-bye.